Court for the Honorable Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit, and for the Honorable Kim R. Gibson on the U.S. District Court for the Western District of Pennsylvania. He's a graduate of George Mason University School of Law. Please welcome Josh Blackman.
Thank you. Thank you. It's a pleasure to be here. My first time at UND, my first time in North Dakota. And you know I really want to be here because it's about 80 degrees back home in Houston, but I came here to be with you all here today. So thank you to Jillian and all the professors who joined us. My topic today is on immigration, and I want to focus on two aspects of the immigration debate. First, I want to focus on the travel ban, which will be before the Supreme Court in a few weeks. And second, I'd like to focus on the issue of the decision broke down on a 5-4 line, but to the surprise of many, the deciding vote was cast by Justice Scalia in favor of the flag burner. Now, Justice Scalia was no fan of flag burners. He once said, if it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. But Scalia said, I am not a king. Indeed, Scalia felt that the answer was compelled by the First Amendment, even though he disagreed with the result. Texas versus Johnson is a good gut check for lawyers. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. This is much how I feel about the travel ban issue. I'm a libertarian, and I generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because executive orders will cause undue hardship to families, to refugees, and others who are seeking a better life for themselves and their families. I am also doubtful the policy would do much to improve our national security. Yet, with my cards on the table, I am firmly convinced that Congress gave the President the power to take the actions he did, and that the Constitution does not bar him from exercising the powers in the manner in which he did. So my discussion of the travel ban will be in 5 parts. First, I want to walk through a history of the travel ban, including statements made by then candidate Trump and now President Trump. Second, I want to discuss the contents of the 3 executive orders which have been halted by the courts. Third, I want to discuss whether Congress has afforded the President the authority to take these actions from a separation of powers Establishment Clause. And finally, I want to give you a preview of the Supreme Court's upcoming arguments next month in the case of Hawaii, this month actually, April 25th, a couple weeks, in the case of Hawaii versus Trump. So our story actually begins before the election in December of 2015. Then candidate Donald Trump called for, quote, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. Over the next few months, Trump shifted his position from a Muslim ban and moved toward what he called extreme vetting of people seeking entry to the United States from certain territories. Or did he? Cue PolitiFact, right? During a July 2016 interview on 60 Minutes, Trump told Leslie Stahl, you can still call it whatever you want, but we'll call it territories, okay? Was that a repudiation? Or weak the nod to the alt-right? However, a week later, on Meet the Press, Trump seemed to clearly repudiate the old policy that Chuck Todd. Alas, the burden of reconciling these statements has fallen to the federal courts, who now take the role as fact-checkers. One judge in Virginia found that the CBS interview connected his initial call for Muslim ban with his final January 2017 immigration order, the missing link. Now it's come to this. Called upon to decide whether the President's immigration orders was lawful and designed to exclude Muslims, the courts have turned to a bizarre question: who's a better interviewer, 60 Minutes or Meet the Press? I think these are probably the wrong questions to be asking altogether. Let's fast forward now to January of 2017, about a year and a half ago. 1 week after the inauguration, President Trump signed the first version of the travel ban. I will call it travel ban version 1.0. It sent shockwaves through our legal order. For 90 days, aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen, 7 countries, were deemed detrimental to American interests, were denied entry to the country. Nationals of these 7 countries. This created chaos. Imagine this. When you got on a plane, let's say in London, you had all of your papers in order. As you crossed the pond, President Trump signed the order. By the time you landed, this new regime was in effect. People were getting detained at the airports. Almost immediately, judges in New York, and Washington, and Virginia, and Massachusetts granted what are called habeas corpus for it to release people who were being held in captivity. Many of these people were green card holders, lawful permanent residents, who had every right to enter the United States. But this was only the beginning of the lawfare. The Washington Attorney General sought a temporary restraining order in federal court to bar the enforcement of Travel Ban 1.0. After only a few hours of argument, a district court judge in Seattle issued a global injunction, not just nationwide, it was global in scope, and it prohibited all executive branch officials from enforcing this order anywhere on planet Earth. President Trump appealed this to the Ninth Circuit. The Ninth Circuit affirmed on slightly different grounds. The president sought en banc review. It was denied. At this point, fast forward to March 2017. President Trump issues Executive Order 2.0, the second version of it. This one superseded the first executive order. The first big change, it removed Iraq from the list of prohibited countries and made clear that green card holders were not going to be subject to the bar. Also, instead of asking whether any given alien themselves were dangerous, the question becomes, does our country, the United States, have adequate diplomatic relations with the foreign country to share information? Once again, this order was challenged in court by the usual suspects, the ACLU, the state of Washington, the state of Hawaii, and once again, a federal district court judge issued a global injunction. There was one judge in Hawaii, one judge in Maryland, putting this issue on hold. The cases were appealed to the 4th and 9th Circuit. Some people can be barred if they don't have any close relation, what's called a bona fide relation. But if a person has a bona fide relation, they can't be barred. What does bona fide mean? The Supreme Court didn't tell us. The lower courts had to figure that out for themselves. But this second order, version 2.0, was also a temporary order. It was never meant to be final. Okay. It was only meant to last 90 days. Fast forward 90 days, and we go to September 24th, 2017. President Trump issues travel ban version 3.0. It was actually a presidential proclamation. Now, Josh, what's the difference between a proclamation and executive order? Nothing really, but I'll call it 3.0 to keep it in sequence. This order was meant to be the final policy. That is, it's no longer temporary in nature. It will be revisited every 6 months, but it would possibly go on for the entire duration of the Trump presidency. So now we have a new country added to the list. Japan was added, North Korea was added, and Venezuela was added. From North Korea. It's a very small number of people coming in. And what about Venezuela? The ban only applies to certain diplomatic officials. So as it stands now, we saw this policy which affects predominantly Muslim nations. Okay. Once again, version 3.0 was challenged in court in Hawaii and in Maryland. The same judges did the same thing over again. They issued global injunctions, sensing a pattern, right? Appealed, the 4th Circuit affirmed, and then the 9th Circuit affirmed. But then something different happened. The U.S. government, the Solicitor General, sought a stay of the lower court's ruling. To the surprise of many, not me, but the surprise of many people, the court granted a complete stay. What does that mean? They allowed the entire travel ban to go into effect. So for the last, 4 or 5 months, the travel means are going to reverse. So I think there's a very, very, very strong chance the Supreme Court rules for President Trump eventually on this. How, I'll maybe discuss a little bit later. But the fact that the court let this go into effect means that Trump is probably going to win, and the lower court's going to reverse. Okay? That's the background. It takes forever to describe. I got that out of the way. Let's talk about the first question. Does the president have the authority to do this? And we learn in common law that the president can get authority from 2 places, a statute or the Constitution itself. I'm going to start with the statute and I'll come back to the Constitution a little bit later. So we have a statute enacted in the 1950s, 8 U.S.C. 1182F. I'd like to read it to you. It's short. It says, whenever the president finds that the entry of any alien or any class of aliens into the United States would be detrimental to the interests of the United States, he made that proclamation, right? He made that proclamation, and for such a period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants. So this gives us a few pieces of information, right? Congress gave the president the power to suspend entry, not just to one alien, but a class of aliens. On what ground? That he deems their entry detrimental to the interests of the United States. And how long can that suspension last for? For such a period as he shall deem necessary. Now, you may study administrative law, and you'll study a case where Congress passed a statute saying the agency can regulate the air to make it clean, right? Or agency can make sure that water is clean. What the heck does that mean? These are very open-ended delegations of agency. Rely pretty specific, right? If the president determines someone to be detrimental, he can deny their entry. Now, what does detrimental mean? Congress didn't define that. It let the president make a judgment of what detrimental means. And they didn't really put a time limit on it. They said for such period as he shall deem necessary, which suggests there might be some duration, some length, but it's up to the president's discretion. If you look at this statute by itself, this seems to give the president the statutory authority to suspend entry of aliens if he deems detrimental. And through this executive order, he's made such a finding. Now, some courts say that, wait a minute, we can't read the statute like this. If we read the statute, Congress is giving the president way too much power. This would run afoul of what's known as the non-delegation, she's nodding, the non-delegation doctrine. Right? Couple of delegations is too broad, and since then they've not had any interest in the doctrine. But the court said, no, we don't need to strike down this law into this delegation doctrine. We say, well, we'll read it more narrowly, right? The president must make specific findings of why a person is detrimental, and the period must have a defined duration. None of these things are in the statute, but courts have read these in. Now, my response to this argument about the non-delegation doctrine actually incorporates the Constitution. Remember I said there are 2 sources of authority, the statute or the Constitution. The Supreme Court has recognized, in a case called Shaughnessy versus Knopf, that the president has an inherent power to exclude. Now, what does this word inherent mean? It's a function of Article 2 of the Constitution. That is, whether Congress gives it to him or not, the president has this power. The courts recognize in a few cases that even if Congress doesn't give the president the power to suspend entry, he can do it on his own. So we have a situation here where the Congress gave the president a very broad delegation of power, and the president also has his own Article 2 power. And we learned from the Steel Seizure case in Youngstown that when the president's acting with the combination of his own authority and authority from the Congress, strict scrutiny of an action where the president is supported by both his own inherent constitutional authority and statutory authority. This is not about the First Amendment. I'll get to the First Amendment in a minute. But in terms of statutory delegation, does the president have the power to do this? That answer, I think, has to be yes. And Presidents Reagan, Presidents Carter have used the power, not to the extent Trump did, but they've used it, and there was never an argument that they ran afoul of the statutory violation. Okay? So that's the first part of my argument here. Let's move down to the First Amendment, which is probably what people are more interested in. They don't care about statutes, right? The First Amendment has the Establishment Clause. And the Establishment Clause you usually see in the context of school prayer and whether you can have funding and whether a city hall can put a Christmas tree out in front. This is usually where you see the Establishment Clause. But it comes in the argument is like this. When President Trump issues this travel ban, and it predominantly affects people from Muslim nations, this shows a disfavor of Islam. This argument has been bolstered not only by the 6 or 7 countries identified, but also by President Trump's own statements, which I read a couple of them to you earlier today. That his own statements from before the inauguration, and to a lesser extent after, maybe, he has shown an animus, that is a hatred towards Muslims. And therefore this action not only violates the Establishment Clause of the First Amendment, but also violates the Fifth Amendment, what's called the Due Process Clause, which has this requirement of equal protection, that the federal government can't discriminate on the basis of religion. There are a couple problems with this, and I'll give you the biggest one. Does the First Amendment and the Establishment Clause apply in the context of immigration? Now, you want to say, Josh, of course it does. And the answer is not so clear. In the religious context, in the immigration context, Congress often does stuff that work visas. You have this visa. There's more categories of visas than I can count. One category of visa, though, that's worth noting is for ministers. If you are a minister, you get a special visa. Now, what's a minister? The regulations define it as someone with a lifelong vocation to religion, like a nun or a monk or a sister or a brother. What if you're like a part-time minister in a faith that doesn't look like that? You might not get your visa. That we have a system that actually challenges your doctrine to decide, do you get this visa? I'll give you another example. During the 1980s, Congress enacted a law that became known as the Lautenberg Amendment, after Senator Frank Lautenberg in New Jersey. And this amendment was designed to help certain refugees in the Soviet Union. Not any refugee. For various visas. The statute says on its face, Soviet Jews and evangelicals. It says it right there in the face. If you were a Soviet Muslim, Soviet Buddhist, you are out of luck. So we have a fairly long tradition of Congress using religion in the immigration context in ways that aren't used in other contexts. I don't want to make this point definitively, but I think I'm probably right about this. The Supreme Court's going to have to do some lifting here. they're either going to say that the Establishment Clause doesn't apply here, or they're going to have to say it applies, but it doesn't apply in any other context because this is special. Because once you put the Establishment Clause into immigration, a lot of asylum law becomes very tricky. Because asylum law asks, do you have a credible fear of persecution? What's your beliefs? What's your religious system, right? That entire inquiry is very much bound up, intertwined, it's entangled with religion in a way that might not even be appropriate for courts to be involved with. So I don't think courts could do it, but they have to be very careful. I'm going to make this prediction. Whatever the majority opinion is for the Supreme Court, it's not going to be citing Twitter, right? It's not going to cite the president's tweets. The lower courts have just been awash in tweet this and tweet that and cite Trump and cite this and cite that. I can't see the Supreme Court issuing a similar ruling. This is not a completely responsible way of ruling, and I think the Supreme Court is going to try and tamp down on it. The court can still rule against Trump, but they don't need Twitter to get there. I don't think they need it at all. But let me make this point a little bit more expressly. There are really two categories of President Trump's statements that are relevant. There's stuff from before the inauguration and stuff after it. You have to leave a lot to reading between the lines, and I don't think the courts are equipped to the kind of fact-checking. Before the inauguration, you got plenty of stuff, right? You have this complete total shutdown, Muslims, he said all that stuff. I think there are very good reasons not to rely on pre-inauguration statements in court, and for a couple reasons, right? One, people on the campaign trail are trying to get elected, and they lie. They lie. They make lots of promises they have no intent on keeping, or maybe they have an intent on keeping it, and realize, well, crap, I can't do that. Also, after a person was inaugurated, they take an oath, they form a government, and they get advice. And their advisors say, what are you, nuts? You can't do that. It's like, okay, I'll try something else, right? Now, does the president come out and say, you know, I can't do that? Maybe the courts would love for the president to say that. I think it's unrealistic. And in fact, even if he apologized, people say, change it, you've just disabled the presidency from existing with an entire section of the world, right? The entire Middle East, perhaps. And I'm going to jump ahead briefly to the sanctuary city issue, but I'll jump ahead briefly to the DACA issue. Courts have actually held that because President Trump made disparaging comments about Hispanics and Latinos, right, that murderers and rapists and building the wall and drugs and all this other stuff, right, that he has an animus towards Hispanics. And as a result, he can't rescind the DACA policy because it's tainted by this animus. If he has, President Trump has offended virtually every demographic you can think of. If he's now disabled from taking actions against Hispanics and Muslims and African Americans, and you go down the list, we basically have a president removed from office very quickly. If the courts can issue nationwide injunctions against any action because of so-called animus he's exhibited, we're in a very tough spot. As much as you might like, and I think the courts have stepped too far out of line in ruling against him. Okay, so let me wrap up on the travel ban. I'll move on to sanctuary cities in a minute. I think President Trump will win on the travel ban issue. The only possible ground he might lose something on is if they find a violation of the Immigration and Nationality Act, if there's some nationality-based prohibition on discriminating against people on the basis of their nationality. I think there's some arguments against it. Maybe I can get into it later in the Q&A. But I think on the whole, the order will be upheld as an exercise of the president's statutory and constitutional authority. The second part of my talk, I want to talk about the sanctuary cities laws. California lawmakers opposed President Trump's pledge to step up the deportations. In response, the state enacted 3 so-called sanctuary measures that were designed Abolitionist states like Pennsylvania actively thwarted the Fugitive Slave Act by throwing slave catchers in jail. South Carolina nullified federal tariffs to protect its agrarian and slave-based economy. On immigration, too, states have attempted to frustrate federal policy from both sides. During the Obama administration, Arizona passed a series of measures that were stricter than federal law and policy. But while states have a broad police power within their own jurisdiction, they can't interfere with federal law, which the Constitution proclaims is the supreme law of the land. This constitutional line. So as a strong supporter of federalism, I see U.S. v. California as an opportunity to restore constitutional order and resolve simmering tensions between federal and state powers. So let me walk you through each of the three laws California enacted. The first challenge statute, styled the California Values Act, limits how states and local officials may cooperate with federal immigration officials. Here's the key point. Absent a judicial warrant, law enforcement agencies in California are forbidden The Supreme Court held in Arizona versus United States 2012, which struck down some provisions of the state's strict immigration laws, that states cannot enact laws that interfere with Congress's plenary power of immigration. Attorney General Sessions argues that the California Values Act defies a 1996 federal law that bars state and local governments from prohibiting the exchange of information regarding an individual's immigration status. The California Values Act, however, does not interfere with federal law because, as the court recognized in Prince versus United States, 1997, Congress cannot commandeer state officials. It is not a of non-cooperation no doubt makes enforcement more difficult, but it doesn't constitute obstruction or interference. The second sanctuary policy is harder to justify. It instructs California's Attorney General to inspect and review detention facilities, both public and private, quote, in which non-citizens are being housed or detained. Now, obviously, there's no problem California wants to impose inspections on its own facilities. But the state exceeds its authority when it targets facilities run by the federal government or contractors. States have the power to review federal with additional constraints. Targeting federal agents for heightened scrutiny violates the so-called intergovernmental immunity doctrine, which you've probably never heard of, but now you will. 2 centuries ago, Maryland sought to impose a tax on the second bank of the United States. Should be coming back to you now, right? In a landmark case of McCulloch. Thank you. In a landmark case of McCulloch v. Maryland, 1819. Make sure you're still awake, right? The Supreme Court held that Maryland had overstepped its authority. Quote, the power to tax involves the power to destroy. You knew where that come from, right? From John Marshall, McCulloch. The Chief Justice wrote that the states lack the power to control the constitutional measures of the federal government, which the Constitution declares of federal facilities in a neutral and consistent fashion. But, according to the government's complaint, the Attorney General has demanded access to various private documents respecting the welfare of persons detained by the feds. To the extent that Congress is imposing additional burdens, to the extent that California is imposing additional burdens on federal immigration facilities and no other federal facilities, this second sanctuary policy is unconstitutional. Third, the final challenge statute is called the Immigrant Worker Protection Act. This is the least likely to survive judicial scrutiny. Under this law, if a federal immigration officer informs a business owner that he employs a criminal alien, the proprietor is barred from consenting to a search of the premise. The state punishes a businessman with a substantial fine simply for being a good citizen, unless the federal agent compels cooperation by obtaining a warrant. Critically, neither the Constitution nor federal law requires a warrant in such a scenario. California's law applies only to immigration officers. Proprietors remain free mandated mission. The Immigrant Workers Protectors Act interferes with federal law. It is unconstitutional by virtue of both the Constitutional Supremacy Clause and the Intergovernmental Immunity Doctrine. Under a federal structure that contemplates a dual sovereignty, the national government should respect the spheres of state control, while states likewise should respect Washington's constitutionally granted prerogatives. Resistance to unpopular laws, whether tariffs or immigration or marijuana, gambling, guns, or a host of other possible conflicts, is permissible only within the bounds of federalism. Thank you very much. And I welcome the questions and comments and anything else you might have. How do you want to do this, Julian? What do you want to do?
We can start with any questions. We can certainly take questions from the audience.
This is not cool. All right, go ahead, Facebook.
Okay, so I'm not exactly sure which what he's referring to, but it was during he asked the question during your travel ban portion of your speech.
Okay.
Sorry.
It was in relation to the allowance for the Soviet Jews and
Yeah, okay.
So the two examples cited were affirmative grants of preference rather than negative bans. Does that distinction matter to the court?
Good question. They were grants of affirmative preference, but they also suggested disfavor, right? By favoring Jews and evangelical Christians, you're disfavoring Muslims. By favoring ministers of a certain type, you're disfavoring others, right? Anytime you give a benefit to one, you're giving it to another. It's disfavoring non-Christian refugees, wouldn't it? Indeed, the initial order had a phrase which they've cut out. It said, "We are giving preference to religious minorities and countries." Well, that would mean in a predominantly Muslim nation that Christian refugees would get a preference. And in a predominantly Christian nation, then non-Christian refugees would get a preference. So the question from Facebook is quite good. I think the response is anytime you favor one religious group, you're showing disfavor of the other one, right? If you're giving funding to, say, all the churches, and you're not giving funding to the mosques in the town, I think that would also be an Establishment Clause violation under this sort of doctrine. Thank you, Facebook, for the question. I would thumbs up.
Continue discussion and talk and questions at that point. So
Thank you. Thank you all so much.
again, thank you for Josh Bachman for being here.
Thank you so much. Where do you want to sit, Julian?
We're gonna,
To the table? Okay.
yeah, we're gonna move this back to a little changeover. Maybe a little bit sooner than all the day.
This table's heavy. It's not going to move. So, it's heavy too.
Yeah, exactly.
No, it's really.
Yeah, really did. Okay. Didn't expect it to be that heavy.
That was really heavy too. Sue, hey, I'm Josh.
Practices
immigration here in town.
Thank you so much for coming. I really appreciate it.
I'm sorry I missed the portion
Oh,
of your
don't worry
talk
about it.
here. I ended
Apparently, it's
up.
on Facebook.
Yeah.
And we'll be doing the panel discussion as well on Facebook and
Okay.
streaming that. So hopefully maybe we'll get some more interaction from there as well. And I know
Who
there's.
are these kids that can't come to school to watch or talk to watch on Facebook?
I know, I have no idea. Well, and I know actually myself, I exited really quick because I have class actually downstairs, and so I went and listened for about 10 minutes, and I have a couple of people
You have class
that,
on-
are,
wow.
that are coming up from that. But it's okay. It's a student leadership class, so Dean Rand was like, "I understand. Go do what you need to do." So it's no problem at all. I have it covered, but because I do know that you'll need to leave about 2:00, correct?
That's right.
So I'm going to go ahead. This is a gift from Elsa and
Oh,
Betsy
thank
for
you so much. Very sweet of you.
I'll give that to you.
Of course, I can't eat it, but I'll eat it.
Yeah.
You'll save it for later.
Yeah,
I'll
you
eat
gotta
I'll
save
save it for
them.
later.
Those are the very best types of all of North Dakota.
Really? What are the
They're
chippies?
called chippers.
Chippies.
Yeah, I mean, every law review article, every law review I send them to. On the floor, on the box, everywhere I go. Very, absolutely. About how to structure conversations. Neither of us are really. I thought we were talking about DACA, so I'm super prepared.
Oh,
for that.
did we have a?
Which is
Oh,
totally
is this
fine.
my bad?
No, it's
I missed part of it, so I.
Okay. Well, I can have my doc if you want. I can do that also.
No,
We can talk about anything, but I don't know how much.
Yeah.
I'm gonna be really.
Well, how about this? How about you can talk? You said you're a practitioner.
Yeah, and so mine is less theoretical.
Does that thing light up? Does that thing light up?
Yeah, isn't that cool?
And I was like, does she have a spotlight on her? And I was like, I'm so confused
Yeah,
right
so it
now.
lights up in the dark with me.
That is so brilliant.
I've never seen.
That's MY artistry.
Nice.
Yeah, my cousin got me on it. So.
Uh-oh. Well, if you want to talk about anything, let's talk about doc. I can talk.
More so than the theory behind the issues and constitutional basis versus non-constitutional basis.
All right. I'll let Professor Johnson take the lead, and then we can go from there. Okay?
Well, and we can just sort of, maybe we can do. We have 30 minutes. We could do like 10 minutes on BAM, 10 minutes on Secretary of City, 10 minutes on DACA or something. I don't know.
Yeah,
Take
sounds
questions
good.
from people.
I will follow your lead.
Right, I was gonna say, yeah.
I'll defer to my host.
Because this is more your wheelhouse than mine, so. Yeah, no,
couple panels I moderated, I
whatever
knew a little
information we
more
can
about
discuss and y'all feel free to do it, I'll leave it to you, so.
All right, let's roll.
Okay,
All
let's roll.
right, everybody, we're gonna get started with our panel, and Professor Kit Johnson is going to take over for this part, and if you do have a question, feel free to raise your hand and ask it at any point.
So we're going to rejoin. You guys have already met Josh Blackman, and I want to introduce you to Sue Swanson. Sue practices immigration here in town and is one of the very few, only immigration lawyer very few in the number of immigration lawyers, was the first here in Grand Forks, and brings a lot of practical experience to the anytime with your questions. And so I'm actually going to start with the travel ban. And Josh, you mentioned that you were concerned about the role of courts taking on fact-checking. And particularly you mentioned about his tweets and the innuendo and stuff. And I have to say that was a moment that I really had pause, because I think of that as courts' jobs. To the extent that they do bench trials or something, right? If you're doing a jury trial, it's not their job to decide facts, but they do bench trials all the time. Judges need to decide facts frequently, even in the context of, like a Rule 46 motion for summary judgment, right? Is there a genuine disputed material fact, right? We ask them to assess facts all the time. How do you justify saying that this isn't their gig?
question. I'm actually writing a paper about presidential free speech. And I think applying the normal rules of evidence and the rules of procedure to political speech poses significant problems because politicians have an obligation to get elected. And once elected, they have an obligation to serve interests that are perhaps different and varied. So looking to a president's words to find intent, I don't think follows the usual rules of how you do with a normal litigant because of where a president works. We have in federal courts this doctrine of political question, right? Also fall into this. Now, this is not legislative history. This is not a comment put in the notice and comment with the rulemaking, for example. These are idiotic tweets that the president sends off at 5 in the morning watching Fox and Friends, right?
But why shouldn't he be held accountable for what he says? He's saying, you admitted terrible things.
He did.
Why should he get a free pass? I'm shocked. Can't wait to read your paper, but I don't think anybody should have a free pass.
So, for example,
If I may add into that, I think there's a difference between tweeting as an individual, tweeting as the person in the position of power that they hold, and the fact that he's holding the highest power in the nation and then sending those tweets is more, he should be held to a higher degree of responsibility. Because it's not just affecting the people within the United States, it's affecting our relationships with other countries as well, and how we're being viewed and treated abroad, and how we're being targeted as individual citizens abroad as well.
So there was a case called United States versus Burr, decided 200 years ago, and involved an indictment against Aaron Burr for treason. You probably know Aaron Burr is the guy who shot Alexander Hamilton. But one of the key aspects of this case was actually John Marshall, the Chief Justice. Very famous case. Jefferson basically refused to hand over the documents that Burr requested. And he handed some of them, but not all of them. And Marshall wrote this opinion which said, in no manner do we treat the president like anyone else. This is an important foundational opinion. The rules don't apply to the president the same way they apply to you and I. They just don't. The Constitution gives two people in the United States power, the president and the vice president. That's it. And these are very specific and unique roles. So we have this litigation called Clinton versus Jones, right? Could you even sue the president while he's in office? The court said you can, but with some limitations. You have to have certain concerns for his scheduling. You have to be aware of where he's going. Can you indict the president? That's a really hard question, right? Because if the president's under indictment, can he actually serve as commander-in-chief, right? Is that going to impair his vision on the world stage? Respectfully, the can only last so long in office, either not through re-election or impeachment and removal. So should the president be held to a higher standard? Yeah, I think his tweets are abhorrent. Are the courts competent to parse together these sorts of political speeches? Now, on the fact-checking front, I can go through the specifics. The courts have screwed up big league, if you will. They've made a lot of mistakes, and they've read statements out of context. And in fact, they've looked at statements from people like Rudy Giuliani, who didn't actually say what they said he said, and they've ignored other statements that are to the contrary. So intent from these statements. I think you can look to statements by the president. Again, I don't think it's impossible, but I think you have to be very careful when you're doing it so as not to limit him. The bigger problem with looking to presidential speech is it causes a disability. My colleague mentioned a minute ago that it impacts our ability to negotiate on the world stage. I think it's actually quite the opposite. I think when you have courts reading these statements to create a level of animus, you actually say to the president, you can't deal with this, right? So the president can't rescind DACA because of his animus towards animus towards Hispanics. And he can't institute a travel policy, a travel ban, because of animus towards this. If you take this to the logical extreme, there are entire areas of the world the president can't be a president over. And that becomes very dangerous. So were this any other litigant, I would not hesitate to say tweets are admissible. They find rules of evidence. You can take notice of them. I think that's fine.
Would have, if you're looking at the facts, it would come out a different way, but they're capable of doing it. So that's a second question. And then a third question is just, you don't think that they're looking at the right evidence because you think the president should be exempt, that this sort of evidence shouldn't be used. Like, those are different issues. Is that a fair synopsis?
Let me try it like this. I think the president's statements can be fair game. I think there are statements to the executive, whether he makes an executive order or if he statements to the president, they shouldn't treat it as any other litigant, but recognize the president's the only person in the country who is accountable to the entire United States, right? Your senators represent one state. Your representatives, maybe in North Dakota, represent one state as well, because it's a district, right? Governors represent the state. The president's unique in this wide responsibility. And because what John Marshall described 2 centuries ago, there has to be a lot of caution looking at it. And any sort of inference which they can draw, I think they should do it charitably. And which is why I think they've approached this, I think, in the proper fashion. And specifically the pre-inauguration statements, I think those are out completely. I think before the oath, I think those statements are out. When you form the cabinet, you get advice, you change your mind, you may not apologize. So pre-inauguration statements are out. Post-inauguration statements, I think, can be used, but with a lot
Your theory, right? This isn't like rules of evidence or case law that backs you up. This is what you would like to see going forward.
Yes.
Okay, you know, I just want to make clear for students because they don't always, aren't super up on it. So, and so we look forward to reading that, this idea that let's cabin those things.
I think there's a question in the back.
Oh yeah, please, Kyle.
So going back to challenges against President Trump's actions as a result of his perceived animus, immigration law itself seems to be a history of animus. If you looked at that from a U.S. perspective, and the political process is where does it end, or should it be okay, I guess?
Do you want to take that? You're the lawyer. You actually do this stuff for a living.
Yeah, it's interesting. I just had a conversation today with a client where I'm saying, let's go sue the government. And she said, her exact answer is, how often do you guys do this? And I said, never. Never. But we're seeing a different day and age with this particular sitting president. And what we're seeing is a lot of permissive behavior going on by the government. And what I'm seeing is because of the tweets and because of the things that he's saying. And by the way, his information is largely false or incomplete. And he creates what he wants to be the image and perception, and that's what the general public is seeing. And then we start seeing this domino effect of negativity and treatment towards foreign nationals. And we're also seeing permissive behavior by the agencies. And directly effectuated is processing times for petitions. So I have a client right now who's been waiting more than 10 months to get her work authorization card. Normally, I would never sue the government over something like this. But 10 months where she is in the type of petition that she has eligible to receive public benefits. Well, why not get her the work card so we can get her off the public benefits and contribute to society? Type of treatment for petitioners. So if you're a student, if you're getting work authorization off of employment or off of a family-based petition, any other petition other than U visas, victims of crimes, T visas, victims of trafficking or domestic violence, okay, those 3 are delayed. All the other ones are getting processed in between 90 and 120 days. Why are we treating these victims who are documenting and proving they've already been victimized? Why are we victimizing them twice? Why do they have to wait 10 months? So for me, it's a disparate treatment issue. And my advice is let's go sue the government.
What are you suing on? Arbitrary and capricious grounds? What ground are you
I
suing
don't know,
on?
that's what I'm trying to, and that's what I'm saying, we don't do this very often. This is me talking today, I haven't put my full argument together. But actually, month processing time, and we're at now month 11 and a half. So we're outside of it. All I'm wanting to do is file a mandamus action in federal court to compel the government to act upon the petition that I've already got pending, not to say how to do it, just act on it.
And those
make a
have to be pretty
decision.
rare. I don't think those happen a
No,
lot.
in this day and age, we are
They're
starting
uptaking.
to file more and more mandamus. I filed a mandamus action on an M400 last year. I was ready to file another mandamus. I'm doing a mandamus on a T visa. That's just the whole point. Now, since President Trump has been in office, how are you going to document why it was delayed? We don't have access to that information. So my only course of action is to go into the federal court system and start filing these mandamus
And the court's
actions.
responses to mandamus petitions?
They get 60 days on day 54, 55. It's amazing.
You
Immigration
granted.
response, and I usually have what I want. Because they're not gonna, what they're not gonna do, and aren't able to sustain a whole bunch of mandamus actions across the country. They're not gonna fly their attorneys everywhere over a simple work authorization.
And they just moved it by
petition.
giving you the petition?
Yep.
Look at that, okay.
So it's, how do you play the game?
And then Kyle, I think in response to kind of the other half of your question that I'd like to point out is, I think for those of you who aren't in immigration law, my guess about what Kyle's referencing in terms of, isn't our history a history of animus, I think that the most infamous historical moment for U.S. immigration was with the Chinese Exclusion Act in the 1800s, which was clearly driven from animus, had a lot to do with the end of the Civil War, and feelings of hostility towards the United States, and sort of seeking and lumping Chinese into them. And figure back to the history of really things are different, right? We don't know what they're going to say. I think what Professor Blackman said in terms of the fact that we have a stay may tip a hand and indicate that they're going to not uphold it, but maybe they really are going to say no. This type of racially motivated law is no longer okay. We may have upheld it in the past, but maybe this will be the moment where things change.
And it's interesting when we start looking at that law, and the effect. I just sat on a panel of immigration attorneys a couple of weeks ago, and we were literally talking about a topic called consular processing, and that's when people go abroad to get their visas, and they get their immigrant visa and re-enter the United States as a legal permanent resident. And we're having the issue right now is because of that law, or it's not a law, excuse me.
Presidential proclamation.
Presidential
Number 3.
proclamation. Their applications are just languishing. And so you have families that are completely separated. I have a client that has two has the ability to do whatever they want with it, and we don't get to appeal any decision that they have. And so I'm thinking because of this executive order, we're going to start seeing a challenge to that non-reviewability as well, because of issues like this, where we're starting to get, you have a legal permanent resident over here with kids that are abroad. There's no way that they're terrorists. We have to do these waivers now. These waivers are either sitting idly or they're getting denied. And that's a different treatment than what you would have, again, for a legal permanent resident from another country. It's kind of similar to that treatment where you were saying one gets favored, one gets disfavored.
The government argues that the entire travel ban is not subject to review. And one way they conduct this thing is just not subject to review, like the consular non-reviewability doctrine. They can dump this entire case on prudential grounds.
Yeah, and so you're asking, should we challenge it? Absolutely.
exception?
It's an interesting question as well.
No, there's a due process of law to protect people outside the United States.
Has that been the grounds for rejecting consular reviewability? It hasn't, has it?
So this is aliens abroad petitioning U.S. courts for review.
Yeah.
Are they, I don't think they're protected by
I
due
don't- they're
process.
not.
Even family though, they've actually.
Well, there's
I mean,
But
petition.
family members can,
They can,
if
but
there's
they still
if there's
won't get an answer.
if there's a constitutional, this is Kerry versus Din.
Yeah, Kerry versus
If there's a
Din.
constitutional violation, you can, but for statutory, it's Congress's prerogative to open up the federal courts.
I thought there was there was certain exceptions for like deportability issues when certain documents have been filed, even that person can't.
Yeah, as a general matter, and this is something which, as a you know, I've been reading a lot about immigration law in recent years. It surprises people that the Constitution doesn't lend itself overseas as some might like it, and the Due Process Clause doesn't really do it. Even with habeas corpus in Guantanamo, the court found in Boumediene that Guantanamo was part of the United States, which is why they could petition for habeas corpus. People in Bagram were not able to petition for habeas corpus. So this is why I say the Establishment Clause is probably a good reason not to extend it overseas in the fashion which some of the lower courts have done.
Do folks have, oh, sorry.
Other question? Oh,
Yeah,
my
other
point
questions? That is
exactly.
Can I follow up? Can I have a follow up?
Please,
Yes,
please,
please.
by all means.
So what about the person that's filing for that on behalf of that person? So it's me filing for my child. Where's my rights? 'Cause,
So,
no,
so,
I'm
so,
in
so
the US.
it's a statutory right. There might be some First Amendment associational rights, but as a statutory matter, I'm sorry, but as a matter of entry, it's purely statutory, and Congress controls that in the federal courts. This is why Kerry v. Din was so unique, that there were some constitutional arguments. Also, the Mandela case from the 70s was a constitutional argument. It's hard to appeal. The response to that is the federal courts are Congress's creatures, and Congress can create a right of review if they sought to, but they're not interested. I'm actually with you on this one. Other questions from Facebook? Anything for you guys? If that iPad starts talking to me, we'll get freaked out. You wink at me, you know. All right, hey, you can ask another question if you want.
It's so many things to talk about now. I know where to begin. It's so much fun. Well, you know, we had said we were gonna. Some of us had watched the movie. I'm talking about DACA. What's your thought about the repeal of DACA and sort of where it's going in the courts these days? So DACA, as a refresher, if students don't know and who are here, was an exercise of prosecutorial discretion that was created by President Obama through a memo, or announced by President Obama, created by a memo by Janet Napolitano in 2012, just saying that certain people who met certain criteria, mainly being young, entering the country at a young age, having would be the United States. This policy existed from June 2012 until I think it was September 2017, when Attorney General Jeff Sessions said, "Hey, we're going to phase out this program." And after he announced the phase out of the program, there were lawsuits filed, and 2 different courts have since enjoined the repeal of DACA. What's your take on that repeal?
Well, and this is my last question. It'll take a couple minutes, but I'll answer this one with care. So DACA is a similar spot for me. I think DACA is a good policy. I think the DREAM Act of citizens and lawful permanent residents that was also unconstitutional and a violation of the separation of powers, that this was not a mere exercise of prosecutorial discretion, but an actual substantive rule that conferred lawful presence without authorization. That is largely irrelevant here, but it does inform my thinking. Whether or not DACA was illegal, the president had the authority to wind it down. That is uncontroverted. The problem with this is that he did it in a very bizarre fashion, and I've been fairly critical of the memo that the Attorney General used to rescind DACA. It was somewhat nebulous. It didn't really explain why he was doing it. They could have done a much better job. I wish I could tell you why they did it this way. I don't know. But here again, I will provide a little bit of a constitutional angle to it. The memo referenced the fact that the president determined that this was unconstitutional. That means something to me. When an attorney general or if this policy is unlawful, it's unconstitutional, that's significant. And so far, the courts that have halted President Trump haven't really grappled with that. In fact, one of the judges in Brooklyn cited me saying, I wish the government raised Blackmun's argument, but they didn't. Okay, I'm telling you what the argument is. It'll matter upstairs, right? If the president says this is unconstitutional and enforcing would violate my oath of office, I have a really hard time with the court saying you must continue enforcing this discretionary policy. Here's how you have to do it, right? Here's how you have to rescind it. This is discretionary. And I think the president has the power to withdraw it as he sees fit. And I don't think that it is even subject to review of the courts. It's a purely discretionary matter. Information in confidence with the understanding that this will be used to help them. And there's a distinct fear that this information can be used to hurt them. I'm actually sympathetic to this idea. It's almost like an entrapment style defense, not exactly, but similar, that someone gave the government information with a promise of help, and then the government turns around and uses that to hurt them. I'm actually sympathetic to that. So I think there might be problems with using information provided by the Dreamers to then deport them. So I think that information might have some due process constraints on it, but there's nothing preventing it from rolling back those grants of lawful presence. Critically, though, Trump tried to go to the Supreme Court early. He saw this so once again, Trump botched this one as well.
So we've been talking relatively present tense and recent future, but where could this go, say within the next 6.5 years? Where could it go on one extreme if the president's objectives are fulfilled, or on the other side if more liberal policies are achieved without any substantive changes in federal statute?
Oh man, I don't have a crystal ball. You want to be more specific? Like,
more philosophizing or just,
oh man.
Where do you see this going?
I'm not sure.
You know,
But this is too amorphous for me. I mean, in the sense of presidential power or what Congress might do with immigration.
This entire debate that's going on.
Yeah.
Of immigration, you gotta be more specific, there's a lot of debates going on.
So I think nothing's gonna happen. How about that? That's my crystal ball. I think absolutely nothing, because in the movie talk about this on the phone with all my reps, and I really thought the DREAM Act was going to pass. What was that, like 2010, 2011?
yeah,
There was-
2012.
2012.
June of 2012.
Yeah, June 2012. I really, really thought this was going to happen. Like, I can feel it, this is going to happen. And it didn't. And it just doesn't, I don't see the political will coming out of Congress to do
Not right
anything
now,
on
not under this
immigration.
president.
And there's a question in the back. Yeah.
Oh, yes. I'm trying to figure out what exactly the problem with the whole and all their authority. So, is it? And I'm thinking about the Youngstown.
Oh, such a good question. Yeah, I got to run. Let me answer this question quickly. There is no statute that gives the president the power to grant what's called lawful presence. No such statute exists. It's only been understood from some various ancillary provisions giving the secretary power of discretion. There is no express authority in Congress to do this. The president doesn't have the constitutional authority to give DACA. I actually argue in my brief that we're back in the third tier of Jackson, right? He doesn't have the statutory authority. Maybe he does, maybe he doesn't. It's a close call. Definitely no constitutional authority, so it warrants very close scrutiny. That is, I think, what turns, right? I think with the travel ban, you have a very precise statute. Such a statute is not present for DACA. Now, I should admit, there's like 5 million law professors who disagree with me. There's a letter signed by a bunch of them saying that I'm wrong. You know, we can all agree to disagree, but you can read my brief if you like. And I gotta run.
You do.
I gotta run.
Thank you so much
Thank you
for
so
coming to
much.
North Dakota.
Thank you so much. Coming here takes a full day of travel, so I need to go home and see my students tomorrow for midterm review. So thank you all very
Oh,
much.
it's been great. Thank you so much.